Hello and welcome to Courts Today by Live Law. Let us get to today's top legal updates. The Supreme Court has asked Assam government to initiate process to deport 63 persons declared as foreigners. In a matter concerning NEET PG 2024, the Supreme Court has issued notice on a plea seeking fresh AIQ Round 3 counselling due to alleged anomalies in State Round 2 of Madhya Pradesh. The National Investigation Agency has opposed MP Engineer Rashid's plea in Delhi High Court seeking interim bail in UAPA case. The apex court has rejected NHAI's plea to prospectively apply the 2019 judgment allowing Solatium and interest for national highway land acquisitions. The Supreme Court has refused to hear petitions challenging 2019 UAPA amendments, saying that the High Courts must decide first. And the apex court has issued notice on RTI activists' plea challenging amendment to election rules restricting public disclosure of poll records. I am your host Urvashi Chauhan with your daily roundup of legal updates from across the country. For detailed reading, you can always visit www.livelaw.in. Make sure to watch this video till the end and do not forget to like, share and subscribe to our channel. In an important update, the Supreme Court bench comprising Justice Abhay S. Oak and Justice Ujjal Bhuiyan today pulled up the state of Assam for not taking steps to deport persons declared as foreigners and for keeping them in detention centers indefinitely. The court expressed surprise at the explanation given by the state of Assam that the steps were not taken as the addresses of the detained persons were not known. Justice Oak clarified that lack of a specific address should not be a reason for indefinite detention. He explained that deportation could still happen by sending the person to the capital city of their home country. For example, if the person is from Pakistan, they can be sent to Islamabad. Justice Oak further emphasized that authorities may never know the exact address, but that should not prevent deportation. Senior advocate Colin Gonsalves, appearing for the petitioner in this case, submitted that Bangladesh was refusing to accept these persons as their citizens and hence they are indefinitely continuing in detention centers in India. SG Tushar Mehta today said that detention centers are not jails in the traditional sense and facilities are provided there as per the directions of the Supreme Court. He added that a person who has undergone detention for more than 2 years is also entitled to bail provided there are 2 Indian sureties. Saying that he will speak to the highest authorities in the executive, the SG assured that all details would be placed before the court and requested for time. The apex court has directed the state to immediately initiate the process of deporting 63 declared foreigners whose nationality was known and file a status report in 2 weeks. The bench further directed that it was the responsibility of the state to ensure that all facilities in the detention center are properly maintained. The state was directed to constitute a committee of officers who will visit the detention centers fortnightly and ensure that proper facilities are available there. The court also directed the union government to give details regarding the persons deported so far. The union was also asked to inform how it proposed to deal with the persons whose nationality was not known. The matter will be considered next on 25th February now. The apex court today issued notice on a plea seeking direction to Medical Counselling Committee to conduct all India quota round 3 of NEET PG 2024 counselling afresh on the ground that there were instances of seat blocking following delay in completion of second round of state counselling in Madhya Pradesh. The petition filed by 3 NEET PG 2024 candidates seeks direction to MCC to cancel the AIQ round 3 of the NEET PG 2024 counselling and conduct it afresh. During today's hearing, senior advocate K. Parameshwar, representing the petitioners, argued that due to seat blocking and delays in MP state round 2, candidates ended up with fewer and less preferred seats in AIQ round 3 of the NEET PG counselling. He explained that counselling follows a step-by-step process where state rounds should only begin after AIQ rounds are completed because AIQ seats are in higher demand. The correct sequence is AIQ round 1, then state round 1, then AIQ round 2 and state round 2 and so on. However, Madhya Pradesh did not complete state round 2 on time, unlike other states. Rajasthan, which faced a similar issue, got an extension from the MCC, but MP did not. Because of this delay, by the time AIQ round 3 started, MP state round 2 was still incomplete. This led to a problem because students who took seats in AIQ round 2 later left them to join MP state round 2. These vacated seats should have been available for AIQ round 3, but since state round 2 finished late, those seats did not come back into the AIQ system in time. Parmeshwar further explained that due to this issue, petitioners in AIQ Round 3 got fewer and less desirable seats. Normally, they could have secured seats in general medicine or cardiology. Instead, they were left with options like anesthesia or dermatology, which they did not prefer. Parmeshwar pointed out that the best remaining seats have now gone to the stray vacancy round. But since the petitioners already got seats in AIQ Round 3, they are not allowed to participate in the stray round, leaving them struck with less preferred options. When it was pointed out that stray round is not over, the bench of Justices B.R. Gawai and K. Vinod Chandran issued notice to the respondent authorities and listed the matter on 7th February. Stay tuned. Moving ahead, the National Investigation Agency today opposed before the Delhi High Court the plea filed by Jammu and Kashmir MP Rashid engineer seeking interim bail in a terror funding case registered under UAPA. Rashid has been in jail since 2019. Currently, he is a member of Lok Sabha representing Baramulla constituency from J&K. Rashid has sought interim bail in order to attend the parliamentary budget session, which commenced on 31st January. The session concludes on 4th April. In the alternative, he has sought custody parole during the budget session. Senior advocate Siddharth Luthra, appearing for the NIA, told Justice Vikas Mahajan that Rashid has an alternative remedy under the NIA Act and a writ petition does not lie to seek the relief. Rashid has actually filed the interim bail application in his main petition seeking expeditious ruling by the trial court on his second regular bail plea. It is his case that the special NIA judge had refused to pass any order in his bail plea despite hearing him on length on the ground that it was not an MP MLA court. Referring to Section 21 of the NIA Act, Luthra said that Rashid must file an appeal challenging the trial court order before a division bench of the High Court. Rebutting this, senior advocate N. Hariharan, appearing for Rashid, said that the impugned order is not an order that denied bail to the lawmaker and thus cannot be challenged in appeal under Section 21. Interlocutory order cannot come as appeal under the statute, he said. Luthra then informed court that NIA had written a representation to Registrar General of the Delhi High Court in November last year to designate the special NIA court as an MP MLA court. He further submitted that the Registrar General recently moved an application before the Supreme Court seeking clarification on the issue. Accordingly, Justice Mahajan has issued notice to the High Court Registrar General to ascertain the status of the clarification sought. The matter will now be heard on 6th February. The Supreme Court has today dismissed the pleas filed by National Highway Authority of India seeking a clarification that court's 2019 ruling in Union of India versus Tarseem Singh on grant of solatium or compensation and interest to landowners shall apply prospectively. In Tarseem Singh case, the Supreme Court ruled that part of Section 3J of National Highways Act 1956 was unconstitutional because it denied landowners solatium and interest that were available under the Land Acquisition Act of 1894. The court had said that when land is acquired for highways, the same benefits given under Land Acquisition Act, including solatium and interest on the compensation amount, should also apply. Specifically, the court referred to sections 23(1)(a), 23(2) and 28 of the Land Acquisition Act, which provide for these payments. This 2019 ruling had ensured that landowners whose property was acquired for highways were not at a disadvantage compared to those whose land was taken under other laws. After this, NHAI moved the court seeking clarification as to whether this ruling would apply prospectively, thereby precluding reopening of decisions where land acquisition proceedings had already completed and determination of compensation attained finality. The Supreme Court bench of Justices Suryakant and Ujjal Bhuya today rejected NHAI's request, stating that giving such a clarification would take away the very relief that the Tarseem Singh judgment was meant to provide. The bench said that the ruling was specifically aimed at ensuring solatium and interest for landowners whose lands were acquired between the years 1997 and 2015. However, the court clarified that this does not mean reopening old cases that have already been settled. Instead, if the judgment were modified or restricted, it would go against legal principles and undermine the finality of a court decision. The court also criticized NHAI, saying that they were trying to evade their responsibility and delay compensation by seeking an indirect way to challenge a settled issue. Therefore, disposing of the appeals, the court directed the competent authority to compute the amount amount of solatium and interest in accordance with the directions in Tarseem Singh judgment. In another update, the Supreme Court today refused to entertain petitions challenging the 2019 amendment to Unlawful Activities Prevention Amendment Act and directed the High Courts to hear it petitions challenging the amendments. The UAPA 2019 was notified, giving the central government power to designate an individual as a terrorist. The amendment allows for notification of individuals as terrorists, while under UAPA 1967, only organizations could be so notified. The bench of CJI Sanjeev Khanna and Justices Sanjay Kumar and KV Vishwanathan was hearing a batch of pleas challenging the UAPA Amendment Act 2019 and the NIA provisions. At the outset, the CJI expressed that pleas required to be heard by the High Courts, as the apex court cannot become the court of first instance. Senior advocate Chandroday Singh, appearing for the petitioners, pointed out that the matter has been pending in the Supreme Court for over 5 years. He submitted that similar other issues are already being adjudicated by the Supreme Court. However, the CJI reiterated that the matter has to be heard by the High Courts first. Further, the CJI agreed to the request that instead of disposing of the petitions, they be allowed to be heard by the Delhi High Court. And lastly, the Supreme Court has issued notice to Union Government and the Election Commission of India in a petition challenging amendments to Conduct of Election Rules 1961, which seeks to restrict people's right to access election-related records. The petition has been filed by Anjali Bhardwaj, who is a transparency activist and has been working on issues of transparency and accountability for several decades. The plea challenges 2024 amendment to Rule 93(2)A of Conduct of Election Rules, arguing that it is unreasonably restricting voters' right to information. Earlier, Rule 93(1) already exempted certain election records from public access, but now the amendment adds more restrictions, blocking access to CCTV footage, videography, reports, and diaries maintained by election officials, such as the presiding officer's diary and returning officer's report. It is argued that this change limits access to records that were earlier available for public scrutiny. The plea further argues that this violates the right to information under Articles 19 and 21 of the Constitution. Also, the Handbook of the Returning Officer 2023 had earlier allowed access to CCTV footage of polling stations, vote counting records, and result copies. But with this amendment, such access may now be denied. The petitioner seeks to strike down the amendment and prays for a court order directing authorities to provide access to election records as per the earlier request. The bench, comprising CJI Sanjeev Khanna and Justice Sanjay Kumar, has issued notice in the petition and tagged it with the similarly pending challenge by Congress Rajya Sabha MP and Congress leader Jairam Ramesh. The matter will now be heard on 17th March. Stay tuned with Live Law.